Something is happening in the United Kingdom that millions of people have not seen coming. It is not making the front pages of the major newspapers. It is not in the government's official press releases. But if you have spent years building your life in this country, if you've been counting the days until you can finally call yourself a British citizen, then what we're going to explain in this video affects you directly. It could affect your plans, your money, your family, and above all, the time you have left to act before everything changes. The UK government is right now redesigning the naturalisation and British citizenship system from the ground up. These are not minor adjustments. These are not administrative tweaks. We're talking about the most profound transformation of citizenship rules in more than 40 years, a transformation that the government itself describes as the biggest immigration overhaul of modern times. And the most important thing to understand is this. Some of those changes are already in effect. Others come into force in the coming months. And a third wave of reforms, perhaps the most serious of all, is expected before the end of this very year. The time to understand this is not tomorrow. It is right now. The path to British citizenship, for the vast majority of legal immigrants, does not happen overnight. It is not something you apply for on your first day. It does not come simply because you spent years paying taxes, working in a hospital, or building homes. It comes in stages, and each stage has its own rules, its own costs, and its own traps. The first stage is temporary residence. When someone arrives in the United Kingdom on a skilled worker visa, a health and care worker visa, a student visa, or a family visa, that permission has an expiry date. It has to be renewed. It has conditions. It has restrictions. It is a fragile right. The second stage is settlement, technically known as indefinite leave to remain, or ILR. ILR is the key that opens a door to something more permanent. The right to stay in the United Kingdom without renewing permits, the right to access public funds, the right to bring family members over. For most routes, this moment arrives after 5 years of continuous residence. You reach that point, you meet the requirements, and the clock that has been counting your days in this country can finally stop. The third stage, the final one, is citizenship. But citizenship is not granted automatically when you get ILR. You have to wait at least 12 additional months after obtaining settlement. You have to pass a series of tests and requirements, pay considerable fees, and convince the Home Office that you are, in every sense of the expression, a person of good character. This journey, for many people, has taken 6, 7, 8 years from the moment they stepped off the plane at Heathrow with a suitcase and a work contract. And now, just when that horizon seemed closer than ever, the government is moving the finish line. The biggest change, the one generating the most debate inside and outside Parliament, is a proposal to double the time required to obtain settlement. The government of Keir Starmer, with Home Secretary Shabana Mahmood at the helm, announced that the standard qualifying period for ILR would increase from 5 years to 10 for most immigration routes. 10 years. Double. But that is not all. For workers in the social care sector, the wait could reach 15 years. And for those who were granted protection as refugees, the proposed threshold is 20 years. The government's justification is straightforward. Settlement in the United Kingdom must be earned, not automatic. The Home Secretary has repeated that phrase in Parliament, at policy events, and in press statements. She argues that the previous system was too generous, that the volume of settlement applications expected over the coming years, driven by record immigration figures between 2022 and 2024, represented an unsustainable fiscal burden, because whoever obtains ILR also gains access to public funds and welfare benefits. The government estimates that around 1.5 million people will apply for settlement between 2026 and 2030. Under the new rules, the vast majority of them would have to wait twice as long. The public consultation on these reforms, called A Fairer Pathway to Settlement, closed on the 12th of February, 2026. The Home Office is currently analyzing responses, and all indications based on press reports and parliamentary sources suggest that implementation could come in autumn 2026, though the government has not formally confirmed any date. What is confirmed is the most disturbing element of the entire reform, retrospectivity. The government has proposed that the changes would apply to people who are already in the United Kingdom, people who have already spent years here, people who arrived under a set of rules that promise them settlement in 5 years, people who planned their lives, their mortgages, their families around that timeline. The calculated impact affects around 2 million people, and among them, an estimated 300,000 are children. Just days ago, on the 23rd of June, 2026, the House of Lords Justice and Home Affairs Committee published an extraordinary report, a report that is unprecedented in the sharpness of its criticism toward the government on immigration matters. The committee, made up of peers with senior legal and political experience, examined in detail the government's proposals on settlement, citizenship, and integration. And what they found was devastating for the official narrative. First, the committee stated that it opposes extending the standard qualifying period for settlement to 10 years. Its members concluded that there is no solid evidence that a longer wait produces better integration. On the contrary, they argued that denying people access to social benefits and legal security for an extra decade could lead to greater exclusion, greater vulnerability to labor exploitation, and greater disconnection from British society. Second, the committee warned that applying these rules retrospectively could be manifestly unfair and potentially unlawful. The language in the report is unambiguous. Imposing these conditions on people who are already living in the United Kingdom under a different set of rules amounts to changing the contract halfway through the journey. Third, the committee identified a data failure that few had flagged so forcefully. The government does not know exactly how many migrants are in the United Kingdom right now. Exit data has not been published since 2020. The Home Office cannot reliably determine how many overstayers exist. And without that data, the fiscal projections underpinning the reform are, at best, very rough estimates. The report also questioned the cumulative cost of the immigration system for the people who go through it. If a migrant arrives on a work visa and follows the standard path to citizenship under the new rules, the total fees paid to the Home Office over that period could exceed £20,000 per adult, not counting family visa renewals, not counting the immigration health surcharge, not counting the cost of legal representation. The government has 2 months to respond to this report. But if recent history is any guide, do not expect a retreat. What is possible, and what legal organizations and migrant rights groups are monitoring very closely, is that judicial challenges could turn parts of this reform into disputes resolved in courts rather than in Parliament. While the earned settlement debate continues, there are changes that are no longer proposals. They are facts. They came into force on the 8th of April, 2026, and anyone considering applying for citizenship needs to know them. First, the naturalization fee for adults rose to £1,709. Adding the citizenship ceremony fee, the total cost for an adult is now £1,839. That money, it must be emphasized, is not refunded if the application is refused. If the Home Office rejects the application, the money does not come back. This is not a technicality. It is a reality that pushes people to resolve every potential issue before applying, because the price of mistake is not just emotional, it is financial. Second, also on the 8th of April, the ILR fee rose to £3,226 per adult. For a family of 4, that is more than £12,000 in settlement fees alone, before even thinking about citizenship. Third, and this is a partial victory for families, the citizenship registration fee for children dropped from £1,214 to £1,000 as a result of a successful legal case known as the Project for the Registration of Children as British Citizens, or PRCBC. The Supreme Court found that charging prohibitive fees to children born in the United Kingdom or raised here for years was incompatible with the best interests of the child. The fee came down. It is an important precedent that some consider relevant to the legal challenges ahead. There is one element of the naturalization process that is destroying applications that appear perfectly valid. It is called the good character requirement, and in 2026 has become the most controversial, most unpredictable, and most painful obstacle in the system. British citizenship is not an automatic right once you have accumulated the required years of residence. The Home Office assesses whether the applicant is, in its judgment, a person of good character. This criterion has always existed, but until recently it was relatively predictable. Minor infractions that had occurred more than 10 years ago could often be disregarded, and irregularities in how someone entered the country could be weighed against years of subsequent integration and contribution. That changed in February 2025, and the change is still hitting applicants in 2026. The new policy states that anyone who entered the United Kingdom irregularly, whether by small boat crossing the English Channel, concealed in a vehicle with false documents, or without the required electronic travel authorization, will normally be refused citizenship. And critically, this applies regardless of when that irregular entry took place. It does not matter if it was 15 years ago. It does not matter if that person was subsequently recognized as a refugee. It does not matter if they have spent a decade paying taxes, raising children in British schools, and working in the National Health Service. Irregular entry becomes, under this policy, a permanent mark against a person's character. This has hit recognized refugees particularly hard. People who fled wars, political persecution, and systematic violence in their home countries. People to whom the British state itself granted official protection because their lives were in danger. Those same people now find that the way they had to reach the United Kingdom prevents them from becoming citizens. The situation reached the courts. In June 2026, the High Court published its ruling in the case of Alibari versus the Secretary of State for the Home Department. The court found that the Home Office policy was legally valid, though it acknowledged the tensions with international refugee law. However, before the case reached that ruling, the Home Office withdrew several of the refusal decisions that had triggered the legal challenge. Some immigration lawyers interpret this as an implicit acknowledgement that the original policy had been applied too rigidly. In April 2026, the Good Character Guidance was updated. The new version specifies that irregular entry should normally be disregarded when it was outside the person's control, including cases involving victims of human trafficking and people who were minors at the time of entry. In addition, refugees who can demonstrate that their irregular entry is protected under Article 31 of the Refugee Convention cannot be refused citizenship on those grounds alone. These are important nuances. But for thousands of people in borderline situations, the uncertainty remains. Beyond the changes dominating the political debate, there are requirements that have been in the system for years, and that continue to be the most common cause of rejected applications. Every year, people who meet the residence requirement and have a clean record lose their application by failing on aspects they assumed were already resolved. The first is the English language level. Currently, those applying for naturalization must demonstrate AB1 level on the Common European Framework of Reference for Languages. But this is changing. From the 26th of March, 2027, the requirement will rise to B2 for multiple routes, including naturalization. B2 is roughly the level associated with advanced secondary education in English. For many people who have spent years working in environments where practical English is sufficient, but who have never formally certified their level, this change could mean months of additional preparation. The second requirement is the Life in the UK test. This exam assesses civic knowledge, the history of the country, how institutions function, the rights and responsibilities of residents. A score of at least 75% is required to pass. The current fee is £50 per attempt, and it is non-refundable if you fail. The good news: anyone who passed the test as part of their ILR application does not need to take it again for citizenship. The concern: Parliament is actively debating a revision of the exam, and experts warn that the version that exists today may not be the same version that exists next year. Taking the test now, if you have not done so already, means sitting an exam with known content and well-established study materials. The third is the absence rule, and this is where the most applications collapse without warning. For those applying for naturalization who are not the spouse of a British citizen, they cannot have spent more than 450 days outside the United Kingdom in the 5 years before the application, and in the 12 months immediately before the application date. The limit is 90 days. For spouses of British citizens, the 3-year window allows a maximum of 270 days of absence. What many people do not know, and this is fundamental to understand, is that this calculation is not made from the date ILR was granted. It is made backwards from the date the citizenship application is submitted. That means someone who traveled extensively in the year after obtaining settlement, because they believe they were finally free to do so, may have accumulated absences that now prevent them from applying for citizenship when they expected to. The clock does not start when ILR is obtained. The clock is always running backwards from the day the application is submitted. If the earned settlement is the change generating the most debate right now, earned citizenship is the shadow coming behind it. And it is important to understand why. They are two distinct reforms that depend on each other but operate at different moments and through different legal mechanisms. Earned settlement, the extension from 5 to 10 years for ILR, can be implemented through changes to the Home Office immigration rules. The government can do this by executive order without requiring a full parliamentary vote. It is faster, more unilateral, and for that reason more controversial. Earned citizenship, on the other hand, requires amending the British Nationality Act 1981 that demands that a bill pass through both houses of Parliament. It is a longer process, more exposed to scrutiny, more susceptible to amendments and defeats. What the government has signaled is that earned citizenship will follow the logic of earned settlement, a longer residency period before citizenship can be applied for, with possible reductions for those who can demonstrate specific contributions to British society. The English language requirement will rise to be 2. The life in the UK test may be reformed to become more demanding, and the points-based system already used for work visas could be extended into the citizenship process itself. For the groups already facing greater difficulties, the combination of earned settlement and earned citizenship could create a double barrier. EU settlement scheme participants who obtained settled status, many of whom did so without needing to demonstrate language ability or pass a civic exam, could find that the new citizenship criteria are significantly more demanding than anything they faced before. Older adults who have lived in the United Kingdom for decades but never needed to formally certify their English. Young adults whose parents obtained settlement through family routes and who now have to demonstrate their own independent contributions. The House of Lords Justice and Home Affairs Committee has explicitly called for these changes to be subjected to greater parliamentary scrutiny, a stronger evidence base, and an impact assessment on vulnerable groups before moving forward. The British citizenship system in 2026 is more complex, more expensive, longer, and more uncertain than at any point in the past 40 years. But inside that complexity, there is a window that legal experts, immigration law firms, and Parliament itself are acknowledging out loud. Those who are already eligible for citizenship under the current rules and who have not yet submitted their application are right now on the side of the rules they know, the rules under which they plan their lives. If earned settlement comes into force in autumn 2026 with retrospective application, and if earned citizenship follows a year after with more demanding language and civic test requirements, those who wait could find themselves waiting inside a system that is no longer the one they calculated. For those who are on the path to ILR, the urgent question is what happens to the years they have already accumulated if the thresholds change. It is a question that does not yet have a clear answer because the government has not published the final details of the transitional arrangements. What is known is that the consultation closed, the analysis is underway, and implementation is expected before the year is out. For those who enter the United Kingdom irregularly, whether as refugees or in other circumstances, the situation is particularly delicate. The 2025 Good Character Policy, though partially moderated in April 2026, remains a landscape of high legal uncertainty. Cases are under review. Challenges are in progress. Before submitting any application, specialist advice from an immigration law professional is not optional. It is essential. For those who are building their documentation, the practical advice is to start now even if the application is still months away. Travel records, payslips, employment contracts, proof of address, medical records, documents relating to children. All of that evidence is far easier to gather in an organized way when there is time and much harder to retrieve under pressure when the deadline is already counting down. The United Kingdom is changing its rules in real time. And the difference between those who understand exactly what is changing and when, and those who find out when it is already too late, is a difference measured not in weeks, but in years of additional waiting. The clock is running. The question is whether it is running in your favor or against you. If this video has been useful to you, share it with someone who needs it. The people most affected by these changes are exactly those with the least access to this kind of information at the moment they need it most. And if you want to keep receiving updates on UK immigration reforms as they're confirmed, this channel is where we will keep covering them.